All right, I think we'll get started. Thanks for joining us. This is Eric Hauge, Executive Director of Homeline, and we're joined by Homeline's Housing Attorney and Research Director, Samuel Spade, who will be doing our presentation today. And I apologize, there's a guy with a leaf blower right outside my office window. So you're joining us today, Wednesday, July 1st at 1:30 for our Many in a series of webinars to an audience of tenants and service providers and advocates regarding Minnesota landlord-tenant law during the pandemic. We've been doing these for a number of weeks since mid-April. Just a reminder about Homeline. We're a statewide nonprofit organization. Our primary program is a free and confidential legal hotline for renters to get advice about their rental housing situation in 4 languages: English, Spanish, Somali, and Hmong. And we've advised over 250,000 renters since opening in 1992. Again, a reminder that we have been doing these webinars on a weekly basis every Wednesday afternoon for an audience of tenants and advocates, and every Thursday afternoon for an audience of landlords and managers. Recordings of most of those previous sessions are available on our website. Some of the rules have changed and the timelines have changed since some of the earlier ones in April, but as a resource we have up on our website. We also have a tab on our website just for those recordings, registration for next week's sessions, as well as some general information and legal postings with some general information related to COVID-19. So with that, I'm going to hand it over to Homeline Housing Attorney Samuel Spade. He's also our Research Director. Again, we got some questions submitted in advance, and we'll tackle those after Samuel goes through some of the general information. We're again going to go through some of the information about estimates about potential number of evictions. We have some specific data on local number of evictions in Hennepin. And then we'll tackle some of those advanced questions. And if you have any questions throughout today's seminar, feel free to submit them via the Q&A box or over the chat feature. So with that, I'm going to hand it over to Samuel Spade.
Hello, everyone, and thank you, Eric. I assume you can hear me?
You are good to go.
All right. So, as Eric said, I'll be taking Mike's place today and talking about evictions during this moratorium period and COVID-19. The first thing to know is that in Minnesota, there are 2 levels of protection for tenants. The first is at a state level, and that is the Minnesota's moratorium on evictions and lease terminations, really in general, through the governor's executive order. This executive order was initially done in March. It has been extended 3 times currently and goes through July 13th, so another couple weeks now. It's basically tied to the peacetime emergency. So as long as the peacetime emergency continues, the lease moratorium or lease termination moratorium will continue as well, unless the governor were to take some action to separate those 2 things. As we said, it has been renewed 3 times already. It will probably be renewed again, is my feeling at this point, given how everything is going, but that is just my feeling. There's no official word, and there probably won't be until we're very close to the deadline, as the governor has in the past, at least if that's any indication, been considering the most up-to-date information that they have on the issue before making the decision to continue it. It could end if the governor ended it. It would probably end if the governor did not extend it. And it could also end if both the House and the Senate voted to end it, which the last time this issue came up, the Senate voted to end it and the House did not. So it continued. There is also federal protection, and that's a little bit rare. The federal prohibition applies to non-payment evictions only. So one thing I should have said is that the lease moratorium really is for, or the lease termination moratorium really is for all lease terminations. It's for evictions, a non-payment, it's for breach of lease, it's even for notices to vacate and those types of lease terminations as well. The federal prohibition essentially bans non-payment evictions, and that protection goes through July 25th. On top of that, once the protection lifts, landlords actually have to give a 30-day notice before they file the eviction, which will really extend it through late August. So under the federal protection, no eviction for non-payment can be filed until around late August. The difficulty with the federal protection is that it doesn't protect everyone. It applies to most or all subsidized housing and some other tenants if their landlord has a mortgage through Fannie Mae or Freddie Mac. We estimate, I shouldn't say we, but other people have estimated that this affects about 20 to 50% of Minnesota rentals. It's a little bit difficult to know because outside of the subsidized housing issue, the only person who would know whether or not they have a loan through the government or backed by Fannie Mae or Freddie Mac would be the landlord. So tenants don't know that. You can do some searching, and people have, there are some databases out there that are trying to collect this information, but it is very difficult to find and takes a lot of work. So it can be difficult to know for the tenant whether or not their landlord is under this and whether or not they will be protected by the federal prohibition in the CARES Act if they're not receiving some type of subsidized housing. Yep, there we go. So every year there are evictions. We have looked at those numbers, and over the last 5 years there's been approximately 16,000 evictions per year. Not all of these evictions are residential. Evictions, when they get filed, just get marked as evictions. Those include commercial evictions. They include foreclosures, where a bank may be evicting a homeowner. So there are other things in there. It's not just residential evictions, but the vast majority are residential evictions. It can be very difficult to get a precise number, because in order to get a precise number, you would actually have to know who the parties were in the case. And sometimes you can look that up and just see that it's a bank and assume that those are foreclosures. And sometimes you'll see that the tenant has a business name and you can assume that that's a commercial eviction. But many times those things aren't there. Many businesses may be under a person's name or something like that, and you can't exclude those from the overall count unless you actually have looked at the underlying case, which would be very prohibitive to do. So our best guess is that there's about 14,000 residential evictions filed on average each year over the last 5 years. And this translates to about 1,100 evictions per month statewide in a normal year. One important thing to know, though, about that number, the 1,166, is that that is an average, and there's actually different amounts of evictions filed each month. Summer tends to be a lot higher, gets lower. December is generally one of the lowest months. There's often a spike in January, probably a little bit of a holdover from December. The rest of winter can be a little bit lower, and then it starts to ramp up again until we get to the sort of the highest months in July and August and September. So one of the things we did for this presentation is we looked at just the numbers of evictions filed May through June. Actually, I should say April through June. I made a mistake there. April, May, and June. And when looking at those numbers, we also looked at the numbers just for Hennepin and Ramsey County. So overall, the state numbers are pretty much what you would expect for that time period. This is on the upswing. So in March and April, May, the numbers are a little bit lower, and then in June, they're actually getting higher, and July, they'll be higher still. And then looking at just for Hennepin, we averaged that out to a little bit over 400 total evictions filed each month. Again, that is all evictions. That's not excluding residential evictions. That's all evictions. And then for Ramsey, that's approximately 200 evictions filed each month. So about 1,200 evictions from May to June, and about 600 evictions from May to June. 1,200 for Hennepin, 600 for Ramsey during that time period. So if that were to hold, when the moratorium is lifted, assuming it gets lifted, let's just say this month, that would be about 3 to 4 months worth of evictions. The moratorium began in mid-March, and there are definitely some tenants who haven't been able to pay rent since March. The Minnesota unemployment rate also is about 5% higher this year than last year. And while most tenants are still able to pay their rent and have still been paying, the number, as we will see in a few slides, there have been more people not paying, and many tenants are able to pay because of the various forms of financial assistance, the federal unemployment, the stimulus checks, and so on. And if those don't continue, which right now they're set in on July 31st, so if those don't continue, that could be a drastic change in income for many people as well, which could affect their ability to pay rent going forward. So looking at some Minnesota specific numbers, there was an article earlier this month quoting Minnesota Multi-Housing Association's numbers. For Class A, are their newest and most expensive rentals. In 2019, the 97% of tenants were current and 94% are current now. So that's a 3% decrease. Their Class B are slightly older rental units, and this they have more data for. 93%, sorry, these are older, means 10 to 25 years, not more data. 93% current as of June last year, and 92% current in June this year. So that's a 1% decrease. And then Class C, their most affordable places, went from 92 in June 2019 to 88 in June 2020, so a 4% decrease. So in general, these decreases are not a lot, but the important thing to remember is that if they were filing evictions against the amount of people who were behind on rent, taking just Class A, going from 3 to 6 would be double the amount of evictions filed for non-payment of rent if the landlords were to file for every single person who was behind. And they don't, and we'll talk about that in a moment, but that would be a doubling of the amount of evictions filed. And same with Class C, going from 92 to 88 is about a 30% increase in the amount of evictions, or the amount of people behind, and that could translate into that much of an increase in evictions filed. The one thing that does appear to be at least slightly good news about these numbers is I couldn't tell for sure, might have to check with Minnesota Multi-Housing, but these appear to be total numbers, so everyone who is current up to that point in June. And so you might have actually thought that this number could be a lot higher, or at least there is the potential for this number to be a lot higher, because it's really, it's just June. This is going all the way back. No evictions have been able to been filed since mid-March. So it could have been even higher.
And I'll jump in really quick to just add that we had questions. We talked about these numbers, these estimates, the Multi-Housing Association survey last week on both of our webinars, and got questions during the webinars and actually follow-up emails too, just about this, and like, where did this data come from, and what does it include? And so I did put in the chat the link to the Star Tribune article that cites the Multi-Housing Association data. I think an important caveat is that data, I think our understanding is that it is a survey of their members, or at least in some way associated with that organization's members, and so it may not be fully inclusive of the entire state and all the different types of rental units that are out there that are owned by different wide variety of different entities, from large property management companies, large landlords, down to small mom and pop type groups.
So recapping that information, it would be about a 92 to 97% delinquency rate last year in June, now 88 to 94%. So somewhere between a 6 to 12% of Minnesota tenants are not current as of June versus 3 to 8% at the same time last year. As Eric noted, it is important to remember that that's from one set of data. They are very large, but it is, as far as we can tell, just their members. So it will skew the data a little bit towards, especially the metro area. And we're probably not going to see a full representation of what it might be for all types of housing and for everywhere in Minnesota from that. So it could be more or less depending on what you're looking at. So even once the eviction moratorium is lifted, there's still going to be additional hurdles for landlords. And one of the biggest one of those is going to be the courts. If landlords do file evictions, we expect that they'll probably file sooner rather than later. But what that will mean is that all of these cases that have not been, the landlords have not been able to file during this time period could all be filed at once or over a very short period of time. If we take the number from the statewide calculation, that could be up to about 1,100 per month. So right now, if you count April, May, June, and July, that's 4 months worth, or about 4,600 evictions that could be filed very quickly. And again, in Hennepin, that number would be about, sorry, I should pull it up here. That number would be about 12 to 1,300. And in Ramsey, that could be about 700 or 800 if the same amount of numbers were filed each time. And that is going to be difficult for courts to handle all at once. They're going to have their volume, I mean, possibly quadrupled. It might not be that bad, or it might actually be worse. No one really knows. But the volume could be extended very quickly, and that will make it difficult for all of those cases to be heard at the speed that they're normally heard. Eviction cases, just as background, normally once they're filed, they're heard within 7 to 14 days. On average, it's around 10 to 14 days in most counties. And at that initial hearing, the tenants and the landlord may reach a settlement, which may resolve it. The landlord may win the court case at the hearing because the tenant might admit some of the facts, which again would resolve it. Or there might be a trial down the road, which could extend it for another week or so. After that, the court can delay the eviction, the actual writ or the forcible removal of the tenant for another week. And then there's a couple of days in that process as well. Normally what we tell tenants is it's about 20 days from the time a landlord files until the time they'll be physically forced out of the property if they lose the court case. With all of these cases, that timeline is probably going to be quite different. They will be different on the courts for sure, and it might even be different on the sheriffs. The sheriffs are the ones who get the writs and go out and enforce these, and they have times and schedules as well to keep, and they can only do so many of them at one time, so there could be some delay even just after getting the writ to when it can be enforced. Normally it's a 24-hour minimum, and it is often longer than that, and it could be much longer depending on how backed up the sheriff's offices are. The other thing that influences this, as the last bullet point in the slide talks about, is the CARES Act. So many evictions, even if the state's moratorium were to lift, many evictions will still be, or many tenants would still be protected under the CARES Act, and those evictions won't be able to be filed until about August. So that should help slow down a number of the evictions being filed, as well as that additional protection that's out there. And so there might be some influence there too. So the question that our office thinks about a lot is whether or not all landlords will actually file the eviction. There's definitely a cost to filing an eviction for a landlord. There's an obvious benefit, which is that if the tenant is not paying rent and may not ever pay rent, having that tenant move so that another tenant can come in is in theory good for the landlord. But in practice, that's not really how it works in a lot of ways. Winning the eviction only means that the landlord gets possession of the unit back. They don't get money from the tenant. The tenant doesn't get a judgment against them except possibly for court costs. And so if the tenant owes 1 or 2 or 3 or maybe even 4 or 5 months when this lifts, the landlord is not going to be able to collect that money from the tenant as a result of the eviction case. Landlords do have the ability to file other cases, the tenant security deposit, etc., to go after the tenant for that money, but in many cases, if the tenant doesn't have enough money to pay rent, they probably won't have enough money to be collectible if the landlord were to win a judgment, which means landlords who evict a tenant probably will not see any of that rent. This is standard normally. Even without COVID-19, most landlords who evict tenants don't get to recoup the rent from the tenants that they evicted for non-payment. And so in cases like this where the amounts might be much higher, the cost of the landlord of evicting could also be much greater if the landlord believes that the tenant can stay and work out a payment plan. And the amount of time that tenants have, as well as some of the federal assistance that has existed and that will hopefully continue to exist in some form, makes that a possibility for a lot of people. And so if landlords and tenants are able to work out a payment plan to recover all or some of that money, that can be a big benefit to the landlord and leverage for the tenant in negotiating. Again, the tenants having the ability to, ability is the wrong word, but in the realistic possibility that if they leave, they'll not be able to pay back the landlord. If that debt maybe exists for the tenant, but the landlord can't collect on it, the ability for the landlord to actually make a deal and collect all of that money from the tenant over time could be very attractive for landlords. So one would hope that many tenants and landlords are actually talking through this right now, trying to figure out payment plans, trying to figure out how that will work. And of course, hopefully other people are out there trying to put forward things like rental assistance, emergency assistance, financial aid, and so on to solve this issue as well, hopefully to be in place when it ultimately lifts.
All right, so that sort of concludes, I believe, the prepared information that we started with. And so we're going to jump to some questions that were submitted by registrants in advance. And I see we already have a number of questions that have come in over chat and the Q&A, so we'll get to those after these. All right, so this is not related to the pandemic necessarily, but a question was submitted. Many landlords now require income to be 2.99 times the rent rather than 3 times. Have these landlords found a perfect loophole to get around the Minneapolis ordinance? So I'm bringing up, I had been planning to do this previously, but you know, the Minneapolis ordinance, again, I'm going to put a link to the page on the City of Minneapolis's website that has a bunch of information, single page handouts, but also more detailed information and links to the actual ordinances. Again, this is just Minneapolis, newly enacted or newly enforced as of June 1st for certain size landlords in Minneapolis alone. I'm putting that in the chat right now. So the question is that a way to get around the Minneapolis ordinance? I'm not sure it does. You know, there's two types, two methods that the Minneapolis ordinance allows for within tenant screening. There's an inclusive screening criteria, which is outlined at that link, exactly what the criteria can involve, the standards can involve, and then there is a individualized assessment. The provision on income is under rental history. If a landlord uses a minimum income test requiring an income equal to 3 times the rent or higher, the landlord must allow an exception to that test where the applicant can demonstrate a history of successful rent payments with an income less than 3 times the rent. So that's what the rule is. I'm not sure if there's much we can comment on in terms of the question that was posed, in terms of if that's a loophole. But we would advise tenants who perhaps see something like this in an application or a listing that they contact our tenant hotline. Additionally, in Minneapolis, again, this is just in Minneapolis, this ordinance is effective just in Minneapolis. We would encourage folks to also contact the Mid-Minnesota Legal Aid, their housing unit, as they are advising and in some cases representing tenants in situations regarding this ordinance. We'd also say that the other place where enforcement is happening is directly with the city. So you can call 311 and ask to have somebody look into it there. I don't know if you have anything else to add, Samuel?
I mean, the only thing I would add is if this goes in front of a judge, I would say that there's a decent chance they might consider what the landlord is trying to actually do. And 2.99, they might just say is the same as 3 times, and that the landlord would have to allow an exception. Also, I would point out that the city could simply, if this gets abused, and that does turn out to be a loophole, the city could simply remove the requirement of it to be 3 times higher and change it to say that if the landlord requires a certain amount of income equal to any percentage, they have to allow the exception. And so that could be something that might happen as well if it turns out to be a loophole that gets abused by landlords.
All right. Then the next question that was submitted in advance, not sure if it's a question or a statement, penalties for landlords who require tenants to move during the governor's stay-at-home order.
I can take that one. I mean, we certainly see a lot of those questions on the tenant hotline. Requiring a tenant to move could come in several forms. You have, of course, the standard forms of evictions, where the landlord is threatening and saying to the tenant that you have to move because you have done something wrong. Again, and then the landlord's eyes, that might be non-payment or breach or something else. It may or may not be true, but the landlord thinks it is, and they're telling the tenant that they have to move for it. In those cases, required is I think the key word, because the simple matter is the landlord cannot require the tenant to move. And if the tenant simply refuses to move, which is hopefully something that the tenant will seek legal advice and make a determination on themselves, but is often the right choice if they simply refuse to move, then there isn't that much the landlord can actually do, because the only way for a landlord to legally force a tenant out is to actually go through the court process. If they attempt anything else, they're going to get hit with some pretty big civil penalties and possibly even some criminal citations. The other thing it could mean are notices to vacate. Is the landlord giving the tenant, say, a 30 or 60-day notice to vacate during that time period? Those are also unenforceable. To some extent, the tenant's recourse might be to simply just ignore the landlord and say, I'm not going to move. You've given me an invalid notice, and I'm going to ignore it. The other thing that a tenant can do in both of these cases is report the landlord to the Minnesota Attorney General. The Minnesota Attorney General has the ability to essentially charge the landlord with a misdemeanor for violating the lease termination moratorium. They have a specific form on their website to file these types of complaints, and we have referred many tenants to that and heard back from those tenants, many of them at any rate, that the Attorney General actually followed up. Now, the Attorney General isn't actually charging a lot of landlords, so they are charging some. Generally, if they get to the point where they're filing criminal charges, the landlord has actually done much more than simply sending a letter or something like that. The landlord has maybe tried to lock the tenant out or done other things of that nature. But they are calling, or at least what we're hearing from our clients is that the Attorney General has called or sent a letter or something to the landlord on the tenant's behalf, basically saying what you are doing is a violation of the governor's order, and if you continue to insist upon it, we may consider process or filing charges. And again, they actually have done that in certain cases where the landlords have been particularly egregious or have refused to retract, etc. And so that is one of the primary penalties that the tenant would have, or sort of proactive penalties. Again, the reactive one is they just ignore the landlord and understand that landlords actually cannot require them to move right now in the vast majority of cases, and they simply do not have to listen to anything that would imply otherwise.
And I'm going to just add a point of clarification here too. You know, the question asked penalties for landlords who are requiring tenants to move during the governor's stay-at-home order. Just for clarity's sake too, there are different things here. The governor's stay-at-home order, which I think then was changed, the name changed as it started to get dialed back. That's just related to, you know, staying at home and what were essential businesses that could continue, and then sort of the dialing back of allowing bars and other restaurants and stuff to start to open in different ways. And so that's not really related to the eviction suspension, which is 20-14. I did post in the chat, you know, related to the stay-at-home order very early on, when it was kind of dialed down the most. We did get a lot of questions about tenants' privacy and then also if they could move during the stay-at-home order. That's pretty much all changed now because most of it has been dialed back. But I did put in the chat a link to our updated post on privacy issues as it relates with the change in the stay-at-home order. Next question is sort of a statement again: not renewing lease with no reason and possible retaliation. So I'm not sure, maybe this is a tenant asking about that a landlord is not just saying we're not going to renew your lease, and maybe the tenant had asked for repairs or something and the tenant thinks it's retaliation.
Yeah, I was also a little bit confused. I'll answer the sort of rephrased question that you put out there, Eric, and then if the person or someone else wants to ask a similar question, we can answer that too. I mean, we are seeing a lot of notices to vacate. They might be retaliatory, they might not be retaliatory. In many cases, it doesn't really matter what reason the landlord is giving. The notice to vacate is simply invalid. The tenant doesn't have to listen to it, doesn't have to move, unless it fits into one of the very few exceptions in the governor's lease termination moratorium order.
All right, so I'm going to jump to some questions that have come in now while we've been going through the previously submitted. This tenant says the landlord, the property management, sent them a lease renewal agreement and the monthly rent increased. I thought I had heard Mike Vra, our Homeline's managing attorney in previous weeks, say at one point that this was not allowed due to the peacetime emergency. Could you please address whether my property can do this? My apartment is not covered by the CARES Act.
In general, Homeline's position is no, the landlord cannot do that. It is a little bit nuanced. The governor's order prevents lease terminations. I probably said that a lot now. Lease renewal on its surface appears to be the opposite of a lease termination. It's saying, let's extend your lease. But in practice, the way it works legally is it is terminating one lease and then renewing it, especially if the lease terms are changing, renewing that lease on different lease terms. And this is particularly true when, as I said, the lease terms are changing, the most common being that the rent is being increased or something along those lines. Again, Homeline's position is that those are not allowed, they're invalid. Lease terminations, because that's effectively what they are. And if you want to see an example of this, just ask the question of, well, why can't the landlord simply raise the rent to $10,000 a month? It's not a lease termination, but of course in practice that would mean the tenant would have to move because very few people could afford to pay $10,000 a month in rent. And so it would be effectively a means of forcing people out. Now there's also a price gouging order that would help there, but that's sort of a, a way to think about it. The nuance comes though in that this is sort of a, well, hopefully a once in a lifetime event. It hasn't come up in a long time. It certainly hasn't come up under a lot of the current statutes that are out there. And to some level, that means that if this gets disputed in court, it will be up to a judge to sort of reconcile state law and common or case law with the emergency order and figure out how to work those two things together and what was actually supposed to happen here, which means that there is a little bit of uncertainty. And so my advice to most tenants, and it really is, it needs to be on a case-by-case basis. It can't just be sort of a blanket thing. But my advice to most tenants is that they want to carefully consider whether they would have agreed to this lease renewal otherwise. In many cases, I think that if the lease renewal is expected, it's what would have happened without COVID, and they wouldn't have minded, or perhaps they aren't as hard hit financially, maybe they aren't having the same economic difficulties, it might not be worth the fight, especially if the rent increase is $20 to $30. Because the landlord will eventually be able to give that rent increase. And so, is it worth a court case with a somewhat uncertain outcome for, say 3 or 4 months at $30 less in rent? Again, though, it could be different. If it's a much higher increase, or if it is a different type of change to the lease term that you might not want, then you might have a different opinion, and it might be worth fighting more in those situations. So it really has to be done on a case-by-case basis, but in general, I would say that lease renewals, especially when they're changing, the lease terms are in fact lease terminations and prohibited under the emergency order.
All right. Couple questions that came in from Linda. This one was related to a question just 2 questions ago about how do you contact the Attorney General. So I'm putting that in the chat. There's the phone numbers for the Attorney General's office. And then there's also a link to the eviction complaint form. The eviction complaint form is available in English, Spanish, Somali, and Hmong. Once you get to that link, there's a drop down at the top right that does different languages. We've also heard from the Attorney General's office that if you dial in, particularly for Spanish speakers, who that you can, they have folks that will answer questions over the phone in those languages as well. And we have heard also from the Attorney General's office that I think they're closing in on having heard something like close to 900 complaints about evictions and lease terminations. All right, another question from Linda. Can Homeline suggest in the press that landlords and tenants have a talk about how to keep families safe and stable and how to stay put? Yeah, I think Samuel kind of mentioned this earlier in today's presentation, just kind of about how what we've been advising and why we think landlords and tenants should be talking as much as possible, trying to figure out settlement type agreements. Anything more to add?
Eric, this is not really my area in Homeline, but it's something you'd want to talk about, any of Homeline's public policy or organizing work on these issues as well.
Yeah, and in terms of what we suggest in the press, we do get asked questions from the media, and we have plenty to say, and sometimes they don't run with everything that we say. So, but we have been pretty public and telling clients, and on our, like I mentioned before, we have been doing these webinars every week since mid-April, and we do one for landlords on Thursdays, and we have the same messaging there about that folks need to work together to sort this out. Follow-up question on this regarding Section 8 voucher program, which is allotted months before March. For March and April and May, does Homeline think landlords might see a benefit to accepting Section 8 vouchers after all?
I think we always think that there's a benefit for landlords accepting Section 8 vouchers. In general, having sort of a guaranteed high percentage of the rent paid by the government is pretty helpful. And I think that here, at least we haven't heard any rumblings at all that Section 8 payments are going to be delayed by this and I would actually be very surprised if that happens. So Section 8 vouchers are probably fairly secure, and the amount of money that they're coming in is coming into the landlord.
Yep, that's one of the clear arguments, pros for the Section 8 program that we've said for a long time is that it's guaranteed rent coming in. So, all right, I'm going to jump over here. Does Homeline know if people in Minnesota realize there are apartments in rural Minnesota that are affordable, sitting empty, which need occupants? Some take vouchers, some are just affordable. $600 to $700 for a one bedroom, $700 for 2 bedrooms, heat not included, water, trash, yard. Downside is almost a complete total lack of diversity, and you need a car. Yeah, in rural areas. So, yeah, I'm not sure if there's as detailed vacancy listings in rural areas, but that's obviously can sometimes be an option for folks if they have the flexibility to move to a rural area. But in some cases, there's not as many job prospects and possibly education or other amenities. All right, and then a question about how are undocumented communities that did not benefit from any of the federal care packages getting help? So anything you want to mention, Samuel? Or?
I mean, one of the big issues with undocumented communities is that they are undocumented in more ways than just one. And a lot of times they don't go through the normal judicial system for a variety of different reasons, and it makes it much harder to track. That said, we note when people call us about COVID issues, and we do follow up with many of those people, and often people who are dealing with this issue follow up with us. So we are seeing, I mean, at this, like many issues, I think affects them, undocumented communities, much more than it is affecting other people, unfortunately.
And there have been, we've talked about this in previous webinars, there have been a number of funds that have been opened up. They were very early on, both the city of Minneapolis and St. Paul opened up specific funds that did not have any sort of requirement about demonstrating documentation. Those were well oversubscribed and sort of was a one-time thing. We are hearing and are sending out information and referrals to folks that call us related to emergency assistance that's becoming available through counties. In particular, in Hennepin County, they've really ramped up, and in a minute here, I'll put it in the chat, the link to the Hennepin County kind of Emergency CARES Act funding, COVID-related rental assistance program that they have. And we have been, it's our understanding that there's not any sort of questions throughout receiving that type of assistance through Hennepin County, where they will, where there'll be questions about documentation. So there, and I've also heard that there's some private foundations that are working on trying to get some funding out to community organizations that serve these communities. Okay, let's see here. We have another question. Template for making a deal in COVID-19 to stay put. Can Homeline advise how to get debt agreements in writing between the parties? Is there a template that we have?
There is not a template that we have. It is also, at least in some ways, a little bit difficult to put one together because what works for each person is quite different. When we are advising tenants about making agreements, one of the key things that we want everyone to look at, though, is to really actually think about where their income is coming from and how much they can afford to make a payment. The problem that many tenants face in making these agreements, though, is that landlords won't really let the tenant do this. They'll require large amounts of payments very quickly. in some ways, moratorium might even be, well, yeah, in many ways it's beneficial, but this might be another way in which the moratorium is beneficial to tenants because it can sort of force the landlord into a longer time frame for payments. But again, the actual way that you would make an agreement, I mean, would be very individual for each person. It would depend upon, you know, their financial situation, and it would be, I think, difficult to come up with a one-size-fit-all agreement. And that we could put out there.
So yeah, contact us and then we can advise, and I'll later put up the numbers again, but our tenant hotline 612-728-5767, and we have an email and attorney system on our website. Question about why landlords wait for tenant protections and fashion loopholes for themselves. What became of the social contract for public health? Yeah, so maybe this is regarding the question posed earlier about the Minneapolis ordinance. Yeah, I don't know if I have an answer for that, but that's, you know, one of the, why do we have an entire chapter of Minnesota law, Chapter 504B, that governs rental housing in Minnesota? It's, you know, it's because for the most part, landlords are the ones that write the contracts. They write the leases, and they decide what's in the leases. And so there was a recognition that there needed to be some baseline protections because leases can be complicated and they govern a very important part of people's lives. So anything more on that, Samuel?
No, I think actually what you just said is very important thing. The reason we have so many laws that protect tenants is because the landlord has the ability to write the lease, and in general does. And so the protections balance tenants out. And sometimes you find new things that need to be balanced. And so you put a statute or an ordinance out there, and hopefully it works. And most of the time they do, but if there's a portion of it that doesn't, it can always be revisited and rebalanced.
Yeah. All right. So question, what has Homeline seen in terms of responses from landlords and or tenants regarding the new City of Minneapolis rental application ordinance that went into effect on June 1st? Again, the rule on that is only in the City of Minneapolis. Is that effective on June 1st? And it's for properties, it's for landlords that have, I believe, 16 or more rental units in the city. It became effective on June 1st. It'll become effective for the rest of landlords and tenants in those units, or prospective tenants seeking those units in December 1st, I want to say. Do you have anything on this that you want
to? We have not seen that many calls on this. Certainly not enough to talk about as a sort of a collection of people. There's been a few individual ones. It's still pretty new as far as statutes go. I know that it's been a month, but it doesn't apply to everyone yet. And you know, many statutes have to be out there for a while before people know about them. So I mean, first of all, maybe everyone is following it, and there's been no issues. Seems a little bit unlikely. There are probably some, but also many tenants might not have heard about this, might not know about it, might not have run into it yet in a way that they feel confident enough to call us, or they might not know about us, you know, for one reason or another, or think that they should call us about this issue. So hopefully it will be followed, but if it's not, as time goes on, more people know about it. More people expect it to be followed, know who to call when it's not, such as the city, you know, our office, legal aid, etc. We'll see a little bit more on that.
Yeah, and I earlier in the chat I did post a link to the city's website that has the information. The city did a number of webinars that I think they're all over now. I think at some point the recordings are going to be available on their website, and we were a part of some of them. Including one that was in Spanish, I think last week or the previous week, as well as our friends at Minnesota Legal Aid. So we're still, you know, part of it is still trying to get the information out there to tenants so they know they have these rights, and that's an important part. All right, Sherry asks, says she, Cheryl, sorry, is in a multi-unit apartment with amenities. Due to the pandemic, they have closed the amenities. Now they open the pool and workout areas, but want tenants to sign a document that the tenant won't sue if they get COVID. And if we don't sign, we cannot use the facilities. Are other apartments doing this? When I renew my lease soon, can they have this as part of a new lease?
Eric, let's see. There it is. Just wanted to have it in front of me while I answered it.
Yeah, sorry about that.
Yeah, so Eric, you're posting the links. We did write an article on amenities in general, and that will cover, I think, most of this. I would say that in general, the landlords do owe the tenant some type of rent abatement for the amenities that are being closed down. Reopening the amenities and allowing people to sign a document that they won't sue is an interesting idea. It would probably be enforceable in certain cases without actually looking at a specific example. I don't want to say, certainly you could write a document that would be unenforceable. That's clear. But without seeing actual examples of these documents, I'm not sure how enforceable it would be. Yeah, I guess I'll leave it at that. And just to the answer, I actually have not heard of a landlord doing this yet. So your landlord appears to have come up with a new way sort of handling this situation.
Okay, Linda is sent in some things that kind of follow up on the previous mention about that there's affordable places in rural Minnesota, in many rural Minnesota communities. There are loads of jobs, lots of education, clean and safe, small town community lifestyle. Yep. Yeah, I'm sure there is. I guess what I was trying to get at was, some folks might be in the middle of, in a situation where it might be difficult to move. But Linda suggests SEMCRA, which is the Southeast Minnesota Multi-County Housing and Redevelopment Authority. They serve Wabasha, Winona areas. And I'll put a link to them in the chat. I know that's the agency that runs the Section 8 voucher, I believe, runs the Section 8 voucher program for this area. And then we got a submission. I wish there were more programs for communities that are undocumented. With Trump's new law, many people who are awaiting their visa or residency are not allowed to apply for government help. This includes medical insurance, or their immigration application will be declined. Yeah, there needs to be significantly more assistance to those communities and to many communities. And in some cases, the public can step up here. We haven't seen that necessarily happen yet in Minnesota with the state legislature and the Minnesota Senate not apparently agreeing to put money towards rental assistance. But as I did mention earlier, we have heard of some private foundations that are working on, and I don't have really a very updated update on this, but have heard that there's some private foundations trying to seek out a way to get funding for these communities who might not have access to traditional emergency funding streams, and have that funding go out in other means, like through community organizations on the ground level in the metro, but also throughout the state. Okay. And Linda mentions 9 out of 10 people in need will not likely get emergency assistance for COVID back rent. People better go to their counties and their families and start begging their churches. Yep. Okay, I'm going to put the link to that Linda shared here in a bit. I think that's all the questions we have. Unless there's any others that I missed. And we can wait a minute here. I guess while we're waiting, I will again just put up the reminder that let's see if I can do this. Just a reminder that we're doing these every week on Wednesdays and Thursdays, and we'll continue to do that. You can access previous recordings on our website, and we will send out an email, and there'll be a link soon to the registration for next Wednesday by the end of the day or tomorrow. Okay, I think with that, unless I see otherwise, I'm not seeing anything else. So with that, I think we'll call it a day a little bit early. And again, want to thank everybody for joining us today. And thanks to Samuel for taking over the reins today. All right. Thank you again, and goodbye.
Thank you.